On the air right now, Paul Ryan. Paul Ryan, former speaker, no, Paul Ryan, vice president, policy and litigation with Common Cause. Of the many things that have the risk of being lost by us focusing on the theater of yesterday's hearing, is one piece of that hearing, one piece of that testimony which regarded the attack, the interference on American elections. And it would be really nice if this were not viewed primarily or merely through a lens of political power. It'd be really nice if this weren't seen through a lens of who would benefit and who would lose if, in fact, we protected the sanctity of our elections. There is White House stonewalling. There has been requests for election security bills. To talk about that is with us right now Paul Ryan, Paul S. Ryan, Vice President at Common Cause. Paul, thank you so much for joining us.
Thanks for having me.
So what are some, what were important takeaways? What are things that you think were missed or you want to make sure aren't missed by what much of America watched yesterday?
Well, one of the things that not a single member of the House bothered to ask Special Counsel Mueller yesterday were questions about the legal standard he applied when he was trying to determine whether or not the Trump campaign, Donald Trump himself, illegally coordinated political activity with Russians. Robert Mueller applied the wrong legal standard. He applied a standard that he said that there is no statutory definition of collusion, so he looked to conspiracy law. And then he went on to say that there is no statutory definition of coordination. So he made up a definition of coordination that required an agreement. And that's in direct conflict with longstanding federal campaign finance law. I have no idea why he did that. And I was hoping we'd hear some questions about that yesterday. No one mentioned it. No member of Congress mentioned it.
Do you have speculation? That is such an incredibly important point that I was not dazzled by the legal work by the Mueller report in their desire to actually get at what was going on. If you were going to make a guess as to motive, why do you think, was there a particular piece of precedent that would suggest going the route that he went? Why do you think that he applied the standard that he applied?
I really have no hypothesis. I have no good guess. I mean, the way he phrased this section of the report, and this is at the very beginning of volume 1 of his report, the introduction, where he talks about how collusion is not a legal term. So he's looking at conspiracy and coordination. And it is, in fact, true that there is no federal criminal statute. There's no provision in the criminal code that deals with this term coordination or defines it. But again, there is a term in the federal campaign finance law, the Federal Election Campaign Act, which can be enforced with criminal penalties that defines all this. So I have no idea why he limited the scope of his investigation. I mean, and what all this means at the end of the day is if you read through volume 1 of the report, everywhere you see Robert Mueller and his team wrote, we didn't find any evidence or strong evidence of illegal coordination between the Trump team and Russians. What he really meant was we didn't find any strong evidence of an agreement between
important. What should this standard have been? And I know for folks, this might seem a little weedsy, this might seem a little detailed, but we got some smart listeners. Our folks care about stuff and pay attention, and getting this level of detail, I think, is really important. So what you're saying, the standard to define coordinations, you're not allowed to coordinate between foreign governments and domestic campaigns for purposes of winning an election. And you're saying the standard they used was whether or not there was agreement, whether or not Donald Trump sat in a room with Vladimir Putin's buddy and said, hey, I want to help elect you president. And Donald Trump said, yes, I would like you to help me. I'd like you to help me be elected president. And if you do that, I will give you the following things. I'll put those in the Republican Party platform, and they shake on it. And there's a videotape of it, and you show the videotape and said, I gotcha. What should the standard have been?
So there's a couple important building blocks or foundational principles in campaign finance law. Number one is that if someone other than a candidate or a candidate campaign staff makes an expenditure, as that term's defined in federal law, it's defined to mean money spent for the purpose of influencing a federal election. If they make such an expenditure in coordination with the candidate, it's treated as a contribution to the candidate. Foundational principle number two is that foreign nationals are prohibited from making contributions to federal candidates in U.S. elections. And number 3, the statute, the Federal Election Campaign Act, defines this term coordination as any expenditure made in cooperation, consultation with, or at the request or suggestion of a candidate. That's number 4. There's no mention in the federal coordination statute of an agreement, requirement for agreement.
Say those 3 words again. 3 words. You said cooperation. What were the other? Consultation?
In cooperation, consultation with, or at the request or suggestion of a candidate.
At the request or suggestion of. Okay, go ahead.
And then in 2002, as a provision in the federal McCain-Feingold law, the Bipartisan Campaign Reform Act of 2002, Congress included a provision, it's Section 214, ordered the Federal Election Commission to strengthen the FEC's coordination rules and explicitly prohibited the FEC from requiring an agreement as part of the coordination test under the FEC's regulations. So all of this taken together makes it abundantly clear that an agreement is not what Special Counsel Mueller should have been looking for when trying to determine whether or not the Trump team illegally coordinated.
We got about 30 seconds before the break. I don't know if you're able to stick with us past the break. I would love to follow up on this, but let me at least quickly ask this question. If it used a standard, not using the word agreement, but cooperation, consultation, or at the request or suggestion of, what is the evidence you would point to suggest that there would have been, that it would have cleared that standard and justified either an indictment or at least a different recommendation?
At a minimum, the Manafort and Rick Gates provision of internal polling data to Russia.
Yeah. Mueller used what he would argue is the wrong, and I would agree is the wrong, legal standard for coordination, illegal coordination of campaign finance activities. He used the standard of agreement when, in fact, what the statute calls for is cooperation, consultation, or at the request or suggestion of. Then I asked the question, well, what turns on that? Why does it matter if you use the standard of agreement versus either cooperation, consultation, or at the request or suggestion of it? He said, well, at the very least, the providing to Russian actors the voter information to be used to impact the elections. Feel free to continue that point, Paul. Thank you so much for waiting so patiently.
I'm happy to have waited. The one other thing I want to mention is that when the Federal Election Commission did strengthen its coordination rules in response to Congress saying, hey, FEC, you got to strengthen your rules, do not require an agreement, a couple of the criteria that the FEC put into the rules that would determine or establish when coordination existed was that if the campaign itself had any material involvement in the spenders, in this case Russia's, decisions about the intended audience for the communication or the timing of the communication. So at a minimum, we know that Paul Manafort, as well as Rick Gates, at the direction of Paul Manafort, provided a bunch of internal Trump campaign polling data to some intermediaries, Ukrainian, Russian, that eventually, we presume, made its way to the Russians themselves who are responsible for this interference, election interference. If the Russians relied on that information, figure out who they were going to target, what states they were going to run their social media campaigns in, what segments of the populations or social media users, Facebook users, for example, should be seeing those ads, then it's quite possible there was illegal coordination. But we don't know, because Robert Mueller didn't look for that type of evidence. Once he concluded, presumably, that there was no agreement, that Paul Manafort did not agree to anything by the Russian or with the Russians on behalf of the Trump campaign, he seemingly stopped looking.
So I want to use an analogy that may or may not be apt, but I think about like antitrust law. I think about like price fixing. Okay, so if I'm Delta Airlines and I call up the head of American Airlines and I say, okay, if you set your if you raise the price of your ticket to $1,200, we will also raise the price of our ticket to $1,200, and we won't try to undercut you by charging $1,100. But we know that's a violation for price fixing. What if I'm the head of Delta Airlines and I just send over to American Airlines the prices that I am going to set, and I do that in advance of setting them, all right? And then I watch to see what they do back. Is that unlawful coordination? I know that the antitrust law and price fixing is different, but I want to look at other contexts in addition to election context.
I think your analogy is a good one. I'm an expert on election law. I've been doing election law for 20 years. I'm not an expert on airlines price fixing antitrust law, but it sounds like a reasonable analogy to me. So
what you're saying is there didn't need to be the return response. Say, oh, hey, thanks for this. There didn't have to first be a request necessarily. Hey, would you please provide to us that election information? But that kind of request had it happened, or more importantly, for your point, had Mueller investigated to see if it had happened, that even if they hadn't added, hey, please give us information, if you do, we will help you win the election. And if you do, and we help you win the election, we will get some consideration for that, some payback for that. That even if there was just the request or just that information and they used it, that could have been enough to show a violation of campaign finance law. I think your point is extraordinarily important. Is that matter now foreclosed because Mueller's testimony is done? Is there any, and of course, Attorney General Barr doesn't want to take down this president. He is there to serve as a blocker for him. Is there anything that can be done with respect to that coordination, that unlawful, your argument of that unlawful coordination?
There's two avenues forward for holding this president accountable for illegal activity in 2016, as well as other illegal activities. And one is an impeachment investigation, perhaps concluding in articles of impeachment. And Common Cause just last night announced that we are calling on Congress to open a formal impeachment investigation into Donald Trump, an inquiry of impeachment. And Congress could do something about this. If Congress looks at this law, concludes that Robert Mueller applied the wrong legal standard, and through its own investigation determines that the Trump campaign violated these campaign finance laws, that would presumably be an impeachable offense. There's a bunch of other grounds for impeachment, or at least an impeachment investigation that we put forth in a report that we published last night that's available on our website at www.commoncause.org. But the other avenue, in addition to a congressional impeachment inquiry, is the Federal Election Commission. The Federal Election Commission has enforcement authority here. I have filed complaints with the FEC on a number of these matters over the past year and a half to 2 years, and the FEC has a job now to take up its civil enforcement investigations and punishing these wrongdoing now that the Department of Justice has seemingly concluded its investigation.
One other thing I want to, and so I heard you, so Congress could do something and impeachment proceedings could do something. One other quick matter before we have to move on, and thank you so much for spending time with us, Paul Ryan again from Common Cause. And this is the matter of the election security bills. That's something that isn't just about Trump, but that is about the sanctity of our elections and the interference in those elections, and that in fact there were bills to address that. And what's happened to those bills? What, McConnell's blocking them?
McConnell's blocking them. He's getting some other senators to block them, other Republican senators. Some of this legislation is even bipartisan. There was a bill blocked yesterday that was introduced by Democrat Senator Wyden of Oregon, as well as Senator Cotton, a Republican from Arkansas. And that was blocked by McConnell. There were a couple other bills that would have required mandatory reporting if a U.S. campaign got contacted by a foreign national who wanted to help that campaign. Under these two other bills that were blocked yesterday, would have required that campaign to tell the Federal Election Commission and the FBI that a foreign national or foreign country was trying to interfere in our elections. All being blocked by McConnell. It's outrageous, to put it bluntly. I mean, Special Counsel Mueller made clear yesterday, not only did Russian interference happen in 2016, but foreign interference campaigns are underway now to influence and hijack our 2020 election. This is a problem all Americans, regardless of party, should care about, and Congress has to act.
What's the argument? Now, I understand the motive, all right, or at least I can understand at least one or two motives. The most conspiratorial of those could be, well, they're sort of in on the fix. The other could just be, well, they're blocking it because they see that, pro-Trump interference in the election helps Republicans, and so why would Republicans stop that? But they're probably not going to say that as their argument. If they, for instance, an analogy I'll use is various voter suppression stuff. They don't come out and say, well, the reason we want to block voter suppression is because we think that young people of color and renters aren't going to support oligarchs and Republicans. What they say is, I don't know, they have a different argument about why it's important, because there's voter fraud or some other thing. What's the argument for not passing for not even allowing a vote on election protection, on election sanctity legislation?
Well, you might have, perhaps it was inadvertent, but you just hit the nail on the head. The argument that they are making now for blocking these election security measures is that these bills are targeting foreign election interference, and they don't have the voter suppression provisions that Republicans want to pass. So these voter suppression bills, the voter ID and other voter suppression tactics, they get dressed up by Republicans as election security tactics. They are solutions to problems that don't exist. Voter ID, for example, it's a policy that makes it harder to vote and doesn't solve any actual existent fraud problem. Their arguments this week, Senator McConnell's argument is, hey, these bills are partisan because they don't include the so-called election security provisions we Republicans want, even though those so-called election security provisions are really voter suppression tactics.